This is Dane Holstrom, Divorce Authority. We're going to be talking about a lot of different subjects in family law. There are some important items that I'm required to share with you so that you understand the limited purpose of my going over all of this information with you. No matter what the specific topic, it's very important for you to understand that this information is not intended as legal advice for any specific person or any specific type or actual case. My sharing this information with you is not designed to create an attorney-client relationship. Everybody's case is different, and nobody's results are the same. Just because we may discuss what happened in some other client's case that may in fact sound similar to yours or some other situation does not suggest that your case or the results would be the same or even similar. The discussion of specific cases are fictionalized and may not be real clients or cases. The purpose of these podcasts is to help you understand the framework of how these issues are decided, provide you a better understanding of the process, and hopefully give you insight as to how you might prepare and conduct yourself and your case to get a better result. There is absolutely no substitute for a consultation or hiring a competent, trained family law attorney, and I encourage you to seek out such an attorney as soon as practical in your case. Divorce Authority is a brand and registered trademark of Holstrom Block & Park, a professional law corporation. I've been practicing family law for 30 years. I've been certified by the state of California as a family law specialist, so I know a thing or two about divorce. I'm Dane Holstrom, and I am the Divorce Authority. All right, today's topic is how do I pay for my divorce? Going through a divorce can be a very trying process. This is true from an emotional perspective involving yourself, your ex-spouse, your children. You can have frustration over the process of how long it may take, disappointment over results in court, or even dissatisfaction or disappointment with your attorney, if you choose to hire one. Today I'm going to talk about the economic side of paying for your divorce. We'll talk about the starting process and the options available to you, and we'll touch briefly upon the concept of attorney's fees from the court, although that's going to be a separate episode all by itself. Our firm practices primarily in Southern California, and in those courts, there have been recent estimates that over 75% of the parties in a divorce case and other family law matters, paternity, custody, and like that, do not have an attorney representing them. This begs the question, is this a matter of choice, or can they simply not afford it? Based upon the thousands of people that I and my attorneys and staff have talked to over my career, it's apparent that the vast majority, this is an economic reality of our system. They simply cannot afford to have competent representation. I'm going to digress for just a second. It is this access to justice issue that has garnered a lot of attention in recent years. There is truly a double standard in the justice system. If you can afford competent counsel, then you are more likely to achieve a better outcome. The old adage of you get what you pay for is often true. This is not to say that the choice of an expensive attorney will dictate a positive outcome. But it is common sense. Hiring even a moderately competent attorney will help you avoid pitfalls in the process that can cost you both time and money. In a matter that is contested, an organized, knowledgeable, articulate, and indeed persuasive attorney will help you get a better result. This is not to minimize the importance of having good facts, together with the ability to apply the facts to the law. Attorneys are part counselors in the context of an advisor, and sometimes even as a therapist. Sometimes we're financial advisors. We also have to be advocates, and we have to advise our clients about every aspect of their decision-making process. But our duty to advocate for our clients in front of the judge, and often in front of the other party or to their attorney, to try to secure a reasonable or meaningful settlement, if appropriate, is what is critical. The problem with representing yourself is, I think in the words of, I'm paraphrasing Abraham Lincoln or somebody else, you have a fool for a client. Not only is there a challenge of you losing your own objectivity as you try to convince the court of your choices as being the better resolution or your set of facts or whatever, Having a disinterested third person who can maintain objectivity is critical to the art of persuasion. Having an emotional or actual investment in the outcome can kill credibility faster than anything. Talking about you get what you pay for, it actually reminded me of one of my favorite lawyer movies of all time, and probably it's one of my favorites because of when it came out. I became a lawyer in 1990, and this movie came out in 1992, and I consider it to be a classic. Indeed, it's a comedy. It's not meant to be, legal art or anything like that. It's a movie called My Cousin Vinny with Joe Pesci and Marissa Tomei. And I absolutely love this movie with, of course, Fred Gwynne, a.k.a. Human Munster, as the judge. And the beginning of that movie, and we're going to talk about this movie throughout this episode, the beginning of this movie, these two young men are traveling, and one of them, of course, is the Karate Kid, Ralph Macchio, now Cobra Kai Revisited, or whatever the title of that is. But Ralph and his buddy are driving through Alabama on a cross-country tour, and they go into the Sack of Suds to buy some groceries and snacks. And then they leave a few minutes later, and of course a few minutes after that, the drama starts when the clerk is robbed and killed by other people, and the police mistakenly arrest our two young heroes. Well, our young hero doesn't have any meaningful assets, so when he's calling relatives to find out how to afford an attorney, they find out it's going to cost $100,000 or more, and they also find out that they have this cousin who recently passed the bar who might do it for free. Enter my cousin Vinny. Well, you get what you pay for, unfortunately, and in this case, fortunately. So in this movie, after finding out that he just graduated from law school and took the bar 6 times and has never had any trial or hearing experience whatsoever, Vinny demonstrates that sometimes you get more than you pay for. Supported by the Oscar-winning Marissa Tomei, they conclusively prove the innocence of the defendants while winning the hearts and minds of the judge and the Alabama jury and pretty much everybody in the town. Given my newness and greenness behind the ears of an attorney at that time, I found this movie truly inspirational as I would be preparing for a trial in my cousin Vinny's cross-examination of witnesses. It inspired me and to develop my skills as an advocate. Needless to say, for the reality of the criminal defendant and for the family law litigant, that hiring your cousin is rarely a good choice, and hiring an attorney who's been practicing for 5 weeks may not go well either. However, choosing to represent yourself is also fraught with perils and pitfalls and many traps. I could not possibly list them all. Choosing to advocate for yourself is rarely a good choice, but there are rare exceptions in people who are able to disconnect themselves, that's the objectivity I spoke about earlier, and from their own life and their own case, and then advocate, both objectively and passionately. So if you choose to hire an attorney, how do you pay for them? This may seem like a simple question with a very simple answer, with a credit card, of course. Well, it's often just that simple. Use your credit card, rack up points or miles for a vacation, a true win-win. This is obviously an oversimplification for somebody who's unemployed or is living from paycheck to paycheck. Hiring the best attorney is simply not an option, regardless of the importance of the issues that someone faces. Indeed, it's not unusual that a couple is up to their eyes in debt, sharing their incomes in a single home. Then they suddenly separate, and their incomes are cut in half with 2 homes. On top of that, there could be child or spousal support. The bottom line is often there's less money after separation than before, and there's no money to pay an attorney. So what do you do? Well, before I get into the methodology of paying your attorney, it's important to know how most family law firms structure the financial arrangement with their clients. The most common arrangement is that the law firm will have the client sign a written retainer agreement. Such an agreement is normally required to be in writing by the State Bar of California. It should contain all the necessary and appropriate terms and advisements to help protect the client. When the client signs the retainer agreement, they then pay the initial retainer. This can be any amount. We have had retainers under $1,000 for a very small or identified specific task, and we've had retainers over $100,000. The amount requested usually depends upon the attorney's hourly rates, the complexities of the issues, and the immediacy of the action that needs to be taken on your case. So if you're going to have an emergency domestic violence hearing and a hearing on custody, and all of this is going to happen in a month, you can expect your retainer to be requested to be significantly higher than if you're getting divorced with no children and no pending hearings. The initial retainer is then deposited into a state bar trust account that's managed by the law firm. The trust account is in fact controlled by the State Bar of California. As your case progresses and the attorney and their staff work on your case, they will typically create a monthly bill that states the work that was done, who did it, what their hourly rate was, etc. Then they get down to the total, and after they invoice you for that month's services, then they pay themselves from the trust fund for that amount of that invoice. They may then ask you to replenish the trust account and put additional money in so that you're always ahead. You're never behind to your attorney. That's a bad place to be in a relationship, and I'll talk more about that in a little bit. Attorneys are required to maintain client funds in a trust account, and if your attorney does not have a trust account, then they are probably functioning outside of the ethical boundaries with regard to this requirement. That's a good reason to second guess either their competency or they may have other ethical issues. So be careful if you find out your attorney is not managing their funds in the way that I've described. Most law firms will expect a client to either pay in advance for the work to be done in the upcoming time period or pay as you go. It's up to the law firm. One of the quickest ways to lose your attorney is to not pay in a timely manner. Well, it's absolutely obvious that the attorney, just like every other professional, wants to be paid for their work. The attorney-client relationship requires that there be an absolute highest duty of loyalty from the attorney to the client. In my experience, is that very little can cause the breakdown of the attorney-client relationship and a duty of loyalty than an attorney allowing a client to run up a significant bill that the client then can't pay. This is a two-way street. The client needs to have a reasonable expectation of what the expenses are going to be, and the attorney has to have a reasonable expectation that the client's going to pay it in a timely manner. If that doesn't happen, then the relationship will absolutely suffer. Now, I have in my career had clients that I've absolutely worked with them because I trusted them. I trusted their history with me. I believed in them. I believed in their case. They reciprocally believed in me and our firm and the work that we were doing for them. And I've made some exceptions for those clients, and I can think of them in my head right now. But I've also had experiences with clients that basically ran up a bill and decided that they didn't need to pay me, in which case, of course, we got off their case. We try to be absolutely forthcoming with our clients about expectations, but we are not fortune tellers. One of the most common questions, and I've talked about this in a prior episode, is that we cannot predict what's going to happen in a case, particularly a case with kids, where anything can happen that can change the complexities and expense of a case like that. If I see that a client is apprehensive or anxious about the cost after we've explained the potential expense, then I'll work with them to see if we can find an alternative solution. Maybe we're not going to do various specific legal works that I'm foreseeing because they simply can't afford it. That's part of the process, is finding the appropriate ground that a client can afford. I don't want to throw $1 million worth of work at a client that can only afford a $10,000 case. I'd like to, but you can't. And that's something that has to be a real understanding between the attorney and client. Is there things we can do, but this is the budget for that. And then we decide on the common ground. Sometimes I may talk to the client and to say, you know what? You've got a great case and I really want to help you with it. However, I believe that my personal hourly rate is simply too high for your situation and I can't justify that. However, I can guide them to one of my associate attorneys who is still very experienced, probably also a certified family law specialist, and then with me, for lack of a better word, mentoring them in this case, they can absolutely handle it as well as I could for a much lower fee. And so we try to plan that. And there are some cases where the client simply can't afford our firm. because of the standard that we hold ourselves to and the amount of work we feel we need to do on some cases, there are times, and it's not infrequent, we will refer the client to another family law firm that we believe can do a better job for them on the budget that they have. This is not a matter of not wanting to help the client. It's a matter of wanting to help the client in the only way that we can that's going to work out for the attorney-client relationship. Some attorneys do limited scope retainers or flat fee arrangements. These are specialized arrangements that are designed to do, for instance, just one court appearance or draft one paper or very limited functions. The attorney is not being hired on an hourly basis to manage their case, but for a specific task. This also can very greatly reduce the amount of fees or the exposure for a large fee down the future that you're not expecting or unable to pay. Both of these methodologies, that is the flat fee and limited scope, are somewhat rarer, but they're becoming more and more mainstream. And largely it's because of the unforeseeability that even if you say, I'm only going to do one hearing, suddenly that hearing mushroom clouds into a big hearing that is protracted over weeks and months, and the attorney's neck deep in it. What do I do? It's not a simple, in the words of my cousin Vinny, a simple in and out procedure, one of my favorite lines. It turns out to be a process that takes weeks or months to finish it up. By way of illustration, the attorney agrees to appear for a client's custody hearing that appears to be very routine. Suddenly somebody shows up claiming child abuse or domestic violence, and the hearing makes a wild left turn that really wasn't expected. That kind of a scenario routinely happens in family law. Well, if I can't afford my attorney, can't I do a contingency fee? Well, you've heard about a contingency fee. Contingency fees are what lawyers do in typically personal injury, med mal cases, things like that, where the lawyer takes their fee out of the settlement or the jury award or the verdict. The problem with that is that under California law, family law lawyers cannot take a contingency fee because you can imagine it would be promotive of divorce. If you decide you want to reconcile and you've hired an attorney who's on a contingency, they may well try to talk you out of it, and that's not what they should be doing. What they should be doing is counseling you based on what your life decisions are. And so family law attorneys cannot do a contingency fee. That does not necessarily mean that attorneys cannot be paid out of the assets to come to you. And that gets a little bit complicated. I will tell you that many, if not most attorneys, are unwilling to get paid later. Now, there are tremendous exceptions. Usually these are really high asset cases where there's no question of the amount of money and the fact that the attorney is ultimately going to be paid. But cases with high complexities and there's no certainty of who's going to get how much money, most family law attorneys will not engage that. The second part of that is if an attorney is competent and they've got a good practice because they've got a good reputation and they know what they're doing, then frankly, they generally don't need to do that necessarily to run their business successfully, and so they don't. So I'm going to go through the most common ways that people find a way to hire or pay for an attorney. Number one is credit cards. We touched upon that. We talked about the tangential benefits, and of course, most credit cards will allow you to pay over time. So if you hire your attorney and you pay him $5,000 or $10,000, you may be paying for a long time, but you're paying a little bit, and you can try to manage the cash flow. There are some collateral issues to credit cards I got to bring up. That has the basis in whether the card is a true joint credit card, i.e. both names are on the statement when it comes, both people are responsible for the bill, or if it's primary somebody else's card and you're just an additional cardholder. Now we get into tactics. In these tactics, I may advise you, hey, you're a secondary cardholder and this card's got a $30,000 limit. I'm going to suggest that you pay your fees on that. Two reasons. First off, you're not going to avoid ending up having to be responsible for that card. You probably will. But if you've got your own $10,000 credit card that the other spouse can't charge on, you may need that for living expenses. You may need that for groceries. Let's protect that. You have the legal ability to charge on the other person's card. I'm not talking about forging their signature or stealing their credit card. Please don't do that. You will probably need to save your money for a criminal attorney if you do that. But what you can do is charge on the card that you're authorized user on simply to secure your attorney's fees and then reserve your funds for your later needs after separation. That is a tactic that is perfectly legitimate. It is also true that you might ultimately end up not having to pay back that credit card through a creative settlement or a later attorney fee order. Obvious clients have to be cautious about which card to use. Using an American Express card where you have to pay the balance immediately that month may not help you. It's still viable for the moment. But if you have emergency issues and you need to do something, then you do what you got to do. All right, another option for funds to hire an attorney, the ever popular family and friends. Borrowing money from family and friends is a time-honored tradition for paying your divorce attorney. Please have an open and honest dialogue with your attorney so you can have an open and honest dialogue with your friends and relatives about how much money they foresee the case is going to cost. There is not a lot worse than you borrowing $5,000 or $10,000 from your aged parents, thinking that that's going to cover your case, and then you find out that that's just the down payment. Have an open, honest conversation with your attorney. While we cannot predict the total cost, a good, competent attorney can certainly tell you the difference between a $10,000 case and a $50,000 case. Number 3, taking cash out of the bank account. This includes, of course, writing checks or other stashes of cash. It still works. But the presence of actual cash, greenbacks, can create numerous issues in your family law case related to where did it come from? Is somebody not telling the truth about their income? You may claim that you took $10,000 out of the safe in the house, and the other side says, oh no, he or she took $50,000. Obviously, counting, itemizing, inventorying the cash is a critical part of that step. And while it may seem that we're digressing, and we are, it's important that as we talk about each and every method, we understand the ripple effects that it can take. You write a check, guess what? The other person on the account, if it's a joint account, could put a stop payment, and you just lost not only your bank account, but your attorney as well. Next, you can sell assets. Under most circumstances, you have the ability to sell assets in order to get money to hire your attorney or for personal living expenses. You may recall from a prior episode we talked about the ATROs, the automatic temporary restraining orders. These are the things that kick in when a divorce is filed that says thou shalt not. And one of those is sell property or borrow against assets. Well, wait a second, Dane, didn't you just say that I could? The answer is, yeah, I did. Because even on the ATROs, those are an exception. So you can. For instance, don't do something silly like sell your ex-spouse's car out from under them, okay, or something like that. But do. For instance, if there's something that you have that you can sell to get money for your attorney's fees, you have the ability legally to do that. Before you do that, please have a conversation with a competent attorney who can advise you about the boundaries of the ATROs and whether what you're contemplating doing makes sense for your case. I mentioned briefly, and it's a side topic, but you can also sell something for the necessaries of life. This is typically food and shelter and utility type stuff, not a new Bentley. Problem exists, however, when you try to sell something or borrow against something when it's in the name of the other spouse. Obviously, you're going to have to get their consent. Surprisingly enough, your soon-to-be ex-spouses rarely are excited about contributing to your attorney's fees. Can you borrow against assets? Well, same issue with the ATROs, but the answer is sometimes you can. Sometimes you can take something to a pawn shop. That's not going to generally get you a lot unless you've got an asset. Of course, they'll give you pennies on the dollar for the value. You got to be careful about that. What about your house? Well, but what you can do, for instance, is if you have a pre-existing home equity line of credit, a HELOC. Well, your spouse doesn't need to sign the check to disperse on the HELOC. You can do that. What about taking a loan on your 401k? That's a great idea. Again, sometimes something happening with the court may block that, but that's generally a good idea. Talk to your counsel about whether or not it makes sense for your case. Bartering. In my younger days, I was willing and more able to work with people who had items that they were willing to part with to satisfy their financial obligation. So what I would do is I would take jewelry in lieu of payment. I would take an old car in lieu of payment. I might take an RV in lieu of payment. And it made sense for the client. In every case where I did that, I made sure that the client was overly protected. I would refer them to another attorney to make sure the deal made sense to them. And at every time, I made sure that the client set the price. In other words, if the client said it was worth $5,000, I'd probably give them $7,000, just because I want to make sure the client understands that I'm not trying to take advantage of them in any turn. I don't do that as much anymore, but I will tell you that younger, hungrier attorneys might, and it's certainly a possibility. I would advise you to be cautious, and if it appears that your attorney is only looking out for their interests and not yours, that you really need to consider looking for another attorney. Okay, a lien on your house. Rather than the HELOC we talked about already, there's a new mechanism, it's probably 10, 15 years old now. In California, it's called a Flarpo, Family Law Attorney's Real Property Lien. Flarpo, catchy, huh? So a Flarpo is a device that the state law says that one spouse can borrow against their house without the consent of the other spouse. Sounds like a great solution. Problem: the way that the law has been applied makes the Flarpo really strongly undesirable for attorneys to do. It puts them at risk that they may never collect anything. It does not allow the attorney to enforce the lien, meaning you can never foreclose, you can never collect. You have to wait in perpetuity if somebody doesn't sell their house. And if financial circumstances change, i.e. the house goes down in value and the client's equity goes down, they may lose all of their fees. So while the Flarpo, while well-intended, is not a real practical device today. Another means of funds, again, it's counterintuitive in most cases, but in some cases it works. If it's an amicable separation, people may even have a plan of what they want to do. They just need somebody to make sure they can navigate the process. Then your spouse may, in fact, volunteer to pay for your fees. I will tell you, in low conflict cases, having competent counsel on both sides really just greases the wheels and makes your case go very, very smoothly. When I say competent, I mean competent and non-adversarial. There are some law firms that make their bones out of turning, small fires into massive conflagrations. I call it pouring gasoline on the fire. And there are attorneys and law firms that they market themselves as being, conflict creators as opposed to conflict resolvers. I am happy and willing and enjoy litigating competent counsel with disagreements. But I frankly do not value professionals that prey on the emotional concerns of people and drive up costs of litigation solely for their own benefits. Finally, a court award of attorney's fees is available. California has several ways to require one party to pay the other party's attorney's fees. Do not expect, however, that a competent, experienced attorney will take on your case based solely on the expectation of ultimately receiving an attorney fee award and ultimately being able to collect those fees. Sometimes it's simply more expensive to get a fee award for a small case that it doesn't justify the expense of doing it. It is our unfortunate responsibility to educate the client that this is how the system works. We have had circumstances where a client would come in with the absolute expectation and belief that their spouse will pay for their attorney's fees. Well, the system doesn't work that way, and they truly believe that it's automatic and all you have to do is go to your attorney and the attorney will work it out, and it doesn't work that way. Getting fees is a process. It requires filing a motion with the court, going to court, litigating it, arguing it, and frankly, you may not get all you're asking for. And of course, it takes the time and money to get the fees. So based upon that, it may not be worth the attorney's fees to go after them in the first place. Sadly, we have to educate the person that came in expecting that they could walk in and just hire an attorney without any money. The reality is you're going to have a plan to hire and pay for your attorney before you walk into their office, before you try to hire them. Do not expect any attorney to take the case like that. Again, few exceptions, usually very, very high asset cases where somebody will get on a case with no money up front. So other than the need and ability to pay orders that I've been talking about, or getting a fee award from your spouse, there's also a provision for sanctions where the court will punish one party by ordering them to pay the attorney's fees of another party because of misconduct in the litigation. I'm sure there are other ways for people to pay their attorneys. Let me be clear, I'm talking here about legal ways. The internet is full of stories taking sex or drugs or both in payment for attorney's fees, often in family law cases where attorneys find vulnerable, compliant clients. And frankly, obviously, that it's bad for the profession and bad for the clients and bad for everybody. An attorney may, as we have done, try to make an accommodation to a client. Indeed, I encourage each of our attorneys, and we've got approximately 20 of them, to have a project case, a case that they are passionate about, where we make a very flexible and liberal fee arrangement with the client. It's important that the client have an investment in the case economically, so they realize it's a team effort, it's collaborative, but it's also important that people have access to justice, and I want to do everything we can to support that. Thank you again for joining us, investing your time in this episode. I hope you found the content worthwhile. If you want more information, download our free ebook, Divorce 101, at divorceauthority.com, or reach us on social media at Divorce Authority. I'm Dane Holstrom. When I do turns to I don't, turn to Divorce Authority. See you next time.